Some of the things that you need to think about in multi-front litigation, whether you're a plaintiff, when you're deciding where are you going to bring a case, when you know ultimately you can anticipate that if we bring a case in the US, the other side may bring a case, for example, in Germany, in a patent case. You need to think about where do you want to bring that first case? What is the time to trial or resolution? I mean, in what form can we most quickly get relief if you're a plaintiff? If you're a defendant, similarly, you may have counterclaims that you want to bring. You want to start another front in another jurisdiction. You have to do a similar type of analysis. You have to consider which case is going to go to judgment first, because there's potential that if a case goes to judgment first, that may have some res judicata or conclusive effect on litigations cases in other jurisdictions. So you really, it's like playing a game of chess. You have to think forward several different moves. So not only procedural questions and substantive law issues, but differences in legal culture and how lawyers practice can be very important. The very simple question, if you have lawyers working in time zones which are, 10 hours apart, 8 hours apart, a dozen hours apart, you're going to have questions about, are you going to be able to communicate in real time? What are the local customs or practices about checking email? At our firm, we're fairly fanatical. I think it's commonplace in our firm for our attorneys to check their email several times an hour. But that isn't true in other jurisdictions. It's not even true in the US. So there needs to be a common mutual understanding about communication, and that's something that needs to be expressly talked about how often are we going to communicate, how are we going to communicate. And I mean, we found it very useful to have regularly scheduled conference calls at a time, hopefully, where somebody doesn't have to get up in the middle of the night to join a conference call, but regularly scheduled calls with lawyers on the phone just to make sure that people are updated and kept current about what's going on. Some general thoughts about choosing the right firm, particularly with respect to the United States. Lawyers in the US, it's probably true elsewhere, have a tendency when, always to say yes if they're asked if they can do something. But there's a big difference between, in the US at least, between lawyers whose practice is primarily transactional and lawyers whose practice is related to disputes resolution and litigation. There are many, many, of course, the basic model in the US for the large law firm is the so-called full-service firms, which have a transactional practice, a litigation practice, a tax practice. And especially foreign companies, I think, may develop a level of trust and comfort with a law firm that they do a lot of transactional and contract work with, and then a dispute comes up, there's a litigation, and there might be a natural tendency to use that same firm. That may not be the best thing to do, because the corporate lawyers, the transactional lawyers who you have worked with and gotten comfortable with on transactional issues will not be the lawyers in that firm who will work on litigation. That'll be a different department. And they'll be happy to introduce you to their partners who are litigators, but you'll be talking to a very, completely different set of lawyers. So I think every time that you're considering retaining litigation counsel, you kind of have to start from the beginning and decide what is the best counsel for this case. And it may well not be the firm that you've used for non-litigation matters in the past. I'm surprised, I think in the US in particular, having experience in actually trying cases is very important. I'm surprised how often clients, when we are interviewed, don't specifically ask questions about our trial experience, our experience with juries, our knowledge of the particular judge, our knowledge of opposing counsel, our knowledge and experience with these particular types of claims. The time to get that information is at the beginning, and I think it's a wise practice when you're trying to decide what lawyers to hire, to get specific information from the firms on those types of issues. And from the standpoint of transnational or multi-forum litigation, I think it's very important to find out whether the lawyers have experience with that type of work. It may be useful if they have offices in other jurisdictions where you think there might be claims, but I don't think that that should be regarded as definitive either. What we're talking about here really is things that can save money, ultimately, make the litigation easier to run if you've selected the right lawyer, but most importantly, control costs, avoid duplication of effort, and get a good result for the client. Just a few things about representing Japanese companies that we've learned that may have been of interest, might be of interest. It's standard in discovery when you're producing confidential or proprietary or trade secret information in the U.S. to enter into so-called protective orders, where the court basically enters an order which the parties typically negotiate and agree to, which says that this type of proprietary confidential information can be exchanged, but it may only be read by or disclosed to identified persons on each side of parties. And it's often the case that a common term is that it only may be shared with in-house counsel, meaning from the standpoint of a U.S. company, someone in who's a lawyer in the general counsel's office. The legal structure in Japanese companies is usually different. I mean, you usually have a legal department which may not be populated by lawyers. And if you use that standard stipulation protective order that can only be shared with lawyers, that may exclude the people in the Japanese company's legal department who really need to see this type of information in order to advise the client. So you need to negotiate it differently. The first pleading in response to a complaint is the answer, and a lot of times you can get more time in which to prepare your answer if you agree to waive service under the Hague Convention. From the standpoint of a plaintiff in U.S. litigation, the Hague Convention is burdensome, it's time-consuming. If you can offer to, since you may know that you're going to get served under the Hague Convention anyway, if you agree to accept service, you might be able to negotiate something in return. That is, for example, a longer period of time in which to do your initial pleading to the complaint. That is an answer. U.S. courts will rarely require a foreign company to bring employees to the U.S. for depositions. So usually it's the case that the party that is the adverse party will have to travel to Japan, for example, in order to take the depositions at the U.S. Embassy. And there's an advantage that can be obtained by negotiating, agreeing, for example, that you will bring some witnesses to the U.S. for deposition in return for an agreement limiting the number of witnesses who will be deposed anywhere, whether in the U.S. or Japan. We've done this in several cases and saved the clients millions of dollars by getting an agreement that, yes, we will save you the trouble of coming to Japan and doing the deposition here. We will agree to bring the witnesses, certain witnesses to the U.S., but in exchange, you agree only to take 6 depositions or 10 depositions. It's a matter of negotiation. 30B6 depositions, this is a powerful tool that some of you may be familiar with under the rules of procedure in the U.S. You can basically, instead of identifying a particular witness by name who you want to depose, you can identify a subject. Say, we want to take the deposition of party X, a corporation, on the subjects of 1, 2, 3, 4. and then the party on the other side is required to educate and produce a witness who's prepared to testify on that subject. It's a very, very useful tool, and you can limit the costs of discovery and deposition practice by utilizing this tool and framing your discovery requests of the other side to cover a lot of different subjects so that they have to educate a witness on all those subjects where possible. And when you are on the other end, you can educate witnesses on multiple subjects and try to produce fewer witnesses. Saving money by over-translating. Translation is very, very expensive. Thinking ahead of time about what is really ultimately going to be important, and in consultation with your lawyers, deciding what is really worth the time translating really pays rewards. Depositions are required to be taken at the U.S. Embassy in Japan. There's a lot of advantages to that. For one thing, they can't go on into the night, which sometimes happens, depositions in the U.S. At the U.S. Embassy, it's over at 5 o'clock and they tell you that you have to leave. So those are some of the things that we've learned in our experience in multi-jurisdictional litigation, especially with respect to Japanese companies. Thank you very much.